requesting the court to finalize. I believe we effectively had a final orders hearing, but at the end of it, there was a bomb thrown, which was, metaphorically speaking, that there had been an altercation at a fast food restaurant. I think court ended up getting a copy of the surveillance footage, reviewed
Correct.
it.
I already let it in evidence, and I did review the surveillance footage. Yes, sir.
So I think the court was. I thought that was what the court wanted to deliberate about, though. But I believe where it landed was joint managing conservatorship. Miss Hines, the mother, is going to be the primary. Actually, I tell you what, if I can let Ms. Cusack address the rulings as far as possession, access, I think we do need. I think we need some guidance from the court as far as non-disclosure. I believe the court ruled that guideline child support was going to be $304. Medical was $68, dental was $11. I believe Ms. Hines is the one carrying the coverage, but I can ask her that if necessary. And then, like I said, requesting the court to accept Ms. Cusack's recitation of the ruling as far as the possession, the access, and the conservatorship.
All right, thank you.
And Judge, I agree with what Mr. Diamond said. I believe that we effectively had a final hearing. I'm not sure if you remember, but it was in person, and so we.
Oh yeah. I remember.
Right. We were all at in your courtroom. Both parties testified. Both parties were able to speak afterwards. So I believe that we're kind of effectively closed on the evidentiary part of it. And I think what the court did was take all of that under advisement pending receipt of that video. So then I sent that. And so I think today is maybe more of a kind of a hearing to enter order and to lock this down. I'll say that there have been tensions in general between both parents, but I'll also say that I really have not heard much since the last hearing. So I'm thinking maybe they are trying to work hard on that because I really haven't heard much. I did have a question. I did receive an email about contact information. So I do think if history has told us anything, these parents need to have things written down to make sure that that there's no room for deliberation on that. And so I'd like some sort of order on whether there's non-disclosure or not. If you'll remember, Judge, there have been issues that were already presented in court and already under testimony and introduced through testimony where each parent has been accused of taking the child from the other parent's period of possession. And both of those have involved a parent going to a location. A father alleged that mother picked up the child from his house while he was at work and the girlfriend was watching. Mother alleged that father picked up the child from the school when it was not his period of possession and took the child. So they both have had allegations with that. So I think this is a case. I'm not a big fan of non-disclosure. I don't think that I think that would be appropriate. Non-disclosure would be appropriate in this case, though, Judge. So that would be my request on that. If we need to take up evidence on that, we can. And obviously, since the parties are each representing themselves, they can tell you whether they agree.
No, I don't think you needed to. Based on everything I remember, everything I've written down, everything I've heard, and everything I've seen, I'll go along with the non-disclosure. But I'm also going to make sure the parties need to understand the court order is the court order. The time frame set forth in the court order for the visitation, the exchanges, and all that are the court order. Anybody who ends up violating that or doing something against that order, and it's brought to me based on the information I already know, information I have in this case, I will have absolutely no problem holding that person in contempt and sentence them to the appropriate time in Bell County Jail. So again, folks, I understand y'all have differences and problems, but the court order is going to be the court order. And if anybody goes to school when they're not supposed to and pick the child up, or go to the house and pick the child up when they're not supposed to because the other person's not there, on a motion for contempt, I'll let you know, because I just talked with another attorney about this. So these circumstances, I will not only
the hearing kicks off with a shocking fast food altercation reveal.
Over what was recommended last time and what I think the court maybe made some provisional rulings on, so that we can make sure that Mr. Diamond and I have all of the bullet points of what needs to go in that order so that there's no dispute, and then the parties can address that as well. I had recommended joint managing with mother primary. I believe the court on that issue, I think was either, I don't know if you ordered it, if you rendered it or not, but it was, the child was in the possession of the mom. I believe the court ordered standard possession order for dad and for the state to also incorporate the fall break into that standard possession order, are some notes that Mr. Diamond found, and I remembered that as well. We did not discuss a geographic, well, actually, I did bring this up in my closing last time. Geographic restriction, the closest we could do is either Texas or maybe a mileage, because Miss Hines is in Killeen and father, Mr. Ariano is in San Antonio. So there's at least that much of a distance.
Okay, well, again, my norm is, and you can ask them about this when you call them as witnesses, I would make it to the central time zone of the state of Texas. All right, we won't go to El Paso, but everything that's east of that mountain line, that mountain time zone line, that's what in the state of Texas would be the norm, and that's what I'll be looking at doing. Thank you.
Thank
Do we have summary judgment on that one, Your Honor?
Yeah, that's going to be the court order. So yeah.
Then I believe the court did establish some support, or at least discuss that. I don't know that we have a start date.
Oh yeah, I got in my docket sheet that this was requested, this was going to be ordered, but again, we hadn't had a final order. But go ahead, thank you.
Right. So the amounts, and we'll need a start date. Medical and dental, I agree with Mr. Diamond. I think last information we had was that mother was covering and dad would provide some cash medical back. We do need to solidify the current meeting point. The court said something about exchange at KPD when he is in Killeen, but then I'm not sure if there was a ruling. They had previously met. This is one where we had to pick, I want to think it was in Kyle. We had to pick a location. And Ms. Hines is shaking her head. So I think there was a meeting point at that point. So I don't know if the court was intending to do Killeen, if the father is in Killeen, but if not, then that meeting point. So I don't know if the docket sheet contains any guidance on that. If there is well, there's going to have to be a meeting point, whether it's in Killeen at KPD or wherever it is. Then I think the visiting parent should notify 12 to 24 hours, or maybe 24 hours before intended visitation, so that both parties know that they're supposed to.
I'm going to make that 72 hours, Ms. Kuzak, and that's going to be some.
Okay.
Yeah, we got them using app close, correct?
I believe so, but if not, I would like that clarified. Yes, Judge.
Oh yeah, that's going to be all communications going forward through app close.
Okay. And then as long as we have orders on non-disclosure, I believe that's all I have on my list of things to double check, Judge.
All right, then. Well, let's get some testimony. And again, I got a lot of these cases where I got people in Killeen, well, in Bell County and in San Antonio. That's it's just San Antonio's military bases down there, everything. So with that, I got a lot of folks. I know we had one case where there was a problem with one of the exchange points not being accessible to the general public because it turned out to be the school police or something like that, and not the standard police station. So
that was mine as well, Judge.
Okay, I'm not sure if that was this case or not, but let's find out one way or the other, and let's see whether or not the exchange is going to be somewhere on I-35 or at the appropriate police department in this area. All right. All right, so at this time, I'll go ahead and ask both Mr. Ariano's on the landline. I can see Ms. Hines at this point, so I ask both of them to raise their right hands and let's get some testimony. Do you both solemnly swear or affirm me? Testimony going to give here today is the truth, the whole truth, and nothing but the truth, so help you.
They're both muted.
Yes.
Yes, sir.
All right, you're both under oath, and the state may proceed. Thank you. And you're muted, Mr. Diamond. Thank you.
Sorry about that, Your Honor. I'm sorry, Your Honor. Were you waiting on me?
Yes. Okay. You can call your first witness, sir.
Thank you, Your Honor. I'll call Ms. Hines. Ms. Hines, will you unmute and state your full name, please?
Venetia Marie Hines.
So let's talk about the insurance for a minute. And I'm sorry I don't have better notes on this. I gave the court some information, but you're the one that covers, is that correct? You're the one that carries, I should say.
I do have insurance for her through KISD. But I know Mr. Ariano is going to say that.
Oh, ma'am, stop. Okay, listen to the question, answer the question, stop. Don't speculate what someone else is going to testify to. You can only testify to what you need to say, ma'am. Thank you. So you have, and the question was, you do have health insurance for the child, and my understanding is it's through Killeen Independent School District, correct?
Correct.
All right, thank you.
And this is really mostly about just making a clean record, and that's where you're employed, Ms. Hines.
Yes.
All right, I appreciate it. I think I will pass a witness, Your Honor.
Okay, thank you. Expected that fast. Ms. Kuzak. You're muted also, ma'am. I'm sorry. Boy, ever since the shutdown yesterday, Zoom wants to take over. So yeah.
Yeah, no, actually I did actually mute myself when Mr. Diamond started speaking.
Okay.
I don't feel like I probably, Judge, need to go over the conservatorship and visit. Well, I guess I do.
I'm gonna go. Yeah, I'm gonna even after the video. The court's gonna go with the joint managed conservator. So yeah, that's no
Okay.
problem.
Ms. Hines, you currently live in Bell County and in Killeen, correct?
Correct.
Okay. Would you agree to a Texas geographic restriction within the central?
That's
Okay,
that's a summary judgment. That's the court's ruling on that one. Thank you.
Thank you, Judge. As to let's see, guideline support that's on. So as to health and dental, how much do you pay for health and dental? Do you know?
Give me a second.
Yeah.
Do you want total for Amaya?
If you can isolate that, yes, please.
Okay. 61, 34.
Or if you have to do math, you can just give us whatever information you have, and Mr. Diamond is good at math.
Okay, so for Amaya, I spend about 50 for her dental. And then her health is about 336, I'm sorry. 313.
313 per month.
Yes, for her.
Okay.
One
health.
wrong move, and it's straight to jail with legal fees piling up.
Her health.
And that's when you say for her, that does not include a portion that covers you, right? That's a separate number.
Correct. Correct.
Okay.
Yes.
Okay. And then, okay, so so moving on to the meeting point, where have you guys been meeting since the last order?
We've been meeting at the normal place is Buda and the HEB in Buda.
Okay. And so with all of the other issues in the past, has that kind of fallen into place on Buda?
As a general, yes.
Okay.
Has it moved? Yes, but generally, yes, that's our meeting place.
And so any moving from that place has been based upon a mutual agreement between you and Mr. Ariano, correct?
Correct.
Or he says, I'm running late, can you do this? And you guys figure it out, right?
Yes.
Okay. Are you okay with that location staying the same, the Buda in Harker, and the HEB in Buda?
That's fine. The reason I had asked is because it was taking 2 hours to get there. And I was asking if it could move closer to Austin, but if not, okay.
Okay, so you're asking for a little bit closer. The other thing that was non-standard from the typical order is that the pickup was at 8 p.m. instead of 6, correct?
Correct.
And that's because that's to give both parties the ability to leave where they are and get to the location on time, because you're having to drive from Killeen through Austin, and he's having to drive in San Antonio traffic, right?
Correct.
Okay. And so the 8 p.m., are you asking for that to stay the same?
Yes.
Is there anything, you kind of paused, is there something else as a secondary factor you would want the court to consider?
No, I was open to even 7, 7 or 8. I'm
Okay.
open to either one.
Okay, well, we can ask Mr. Ariano and see if both parties agree to that, but you would agree to 7, 7:30, or 8, right?
Correct.
Okay. And then you're asking probably for Mr. Ariano to let you know at least 72 hours before visitation, so you know whether to get on the road or not, right? Like if he's not going to be able to exercise, you don't want to drive to Buda or wherever, right?
Correct.
Okay. Have you guys been using App Close?
Yes.
Okay, and so you're okay with sticking with that, right?
Yes.
Okay, and then on the issue of non-disclosure, do you have a stance on that? Do you think that that's probably a good idea?
So I understood as far as our personal information being non-disclosed, and I guess maybe the clarification that I wanted was about the babysitter, which is what I had emailed about. Do we disclose babysitter or no?
So, I'll ask you questions about that. So you sent me an email wanting to know if Mr. Ariano had to let you know where the babysitter was, right?
Yes.
And have like the babysitter's contact information, right?
Correct.
Okay. And then I advised that the standard order has rules on notifying the other parent about things like schools and daycares, right?
Correct.
But it does not typically cover, third-party babysitters, like somebody who has to cover for, not for a school purpose or something like that, right?
You
Well,
did,
that's,
and I
that's
get,
what I told you. I know that you don't agree with that, but that's what I told you, right?
yes, yes.
Okay. And then are you asking the court to make a decision on the babysitting issue? To where both parents, are you saying that you feel that it is in the best interest of your child that both parents be ordered to notify the other parent about babysitter contact information?
I'm not gonna go there, Ms. Kuzak. If it's a licensed daycare facility or something like that, I will order it. But if somebody wants to use an individual, that's just not going to be technically enforced. But you can use your friends, your family, your mom, your coworkers. That's just going to be way too much. So, but if anybody uses a licensed daycare facility or some as far as where the child is staying or going to be, I count that like school. But as far as individual babysitters, I've never done that in 20 years, and I don't want to start. I don't want to go down that slippery slope now. So again, each party gets the right to choose who they want. But remember, they have to keep in mind that once you choose somebody, that's your responsibility. So if something messes up, it's going to be on you and not on the other person. So, but again, I'm not going to go with individuals. So, each of those have the right to use the teenage babysitter down the street or the licensed person with the master's in child behavioral sciences if they want to. Okay, thank you.
Okay, Ms. Hines, I believe that covers a lot of the issues in addition to what the court's already ruled on previously. Do you have any areas that you feel need to be clarified that we need to add to this list to make sure we have a good, solid, clear order?
The only thing that I would ask for is that for fall break, can we alternate versus it just being one way? Can we alternate fall break?
Okay, so you're asking to alternate, I guess similar to spring break where it's like evens or odds kind of thing?
Oh, I thought spring break was given to him. That's why I was asking for the alternating of the fall break, because I thought spring break was all of
Yeah,
his.
that's part of the standard possession
Over
of
100.
more than 100 miles. But yeah, I can do. We can alternate this fall, ma'am. That's not a problem.
Okay.
And are there any other issues that you feel need to be clarified for you to have a clear order that you can follow with Mr. Ariano?
No.
Okay, I pass the witness, Judge.
And Ms. Kuzak and Mr. Down, know for the record that for fall break, Ms. Hines gets even years and Mr. Aliano gets odd years. So long as there is a fall break, that can be there and that cannot be there. So, all right, thank you.
So Your Honor, again, I guess I would ask for summary judgment, directed verdict, whatever the court want to call it. My notes indicate that I believe the court has already calculated the medical and the dental. I mean, if not, I can revisit it, but I believe the court calculated that 3% came to $68 on the medical, and 0.5% came to $11 on the dental. And I believe
I
that's
know that's
because
the amounts I got written down on my docket sheet. I did not know what the calculations were based on the actual percentage amount, but that's what I had written down on my last docket sheet. So yeah, that's what I'm looking at, sir. Thank you.
all right. Thank you, Your Honor. Then in that case, I have no further questions.
All right, now let's just show. Okay, and I'm pretty sure y'all check with them, make sure nobody's changed jobs, that those circumstances hadn't changed. So at this time, anything on redirect to this witness, Mr. Diamond?
Nothing, Your Honor.
All right, call your next witness, sir.
I don't know that I even have any questions of Mr. Ariano. I think I probably let Ms. Cusack go. And
all right, then I'll let Ms. Cusack go with that one too.
So, I mean, the circumstances had changed since the last time you spoke with me. I was working at Six Flags. Six Flags was purchased by Cedar Park and went through changes, and there were a lot of people that were let go. So,
all right, so,
I don't have a permanent job anymore.
I'm sorry. Well, are you okay? Well, I'll say again, sir. You just made a statement, but that's not the way we do this. I'm gonna let Ms. Cusack call you, and that was gonna probably be part of her information on whether or not you still have the same current job or that has changed and what your current income is.
Okay, sorry. I was.
Okay, I'm surprised that didn't get that. No, that didn't come up in the when did y'all talk to each other before this?
No, Judge.
no, Your
No,
Honor.
we have not.
That's why.
No.
We treated this like a continuation of like basically that there was already a final order. And
Well,
that
let's see where it's working now and see whether or not it's still working for, even though they were purchased. Obviously, they're still in operation. So let's find out what the current income is and what's there. Thank you.
Okay.
So,
Thank
Mr.
you.
Diamonds, that's on you now, sir.
Yes, sir. Yeah. So thank you, Your Honor. I'll take that back.
And that's why I was just going by the statement, that was preceding that.
Yeah, if I'm wrong, I'm wrong, Mr. Ariano. So I will call you as a witness. Will you state your full name, sir?
Randy Ira Adiano.
Okay. So I think the last time we were in court, I think you testified that 8 months out of approximately, that's the key word there, 8 months out of the year, you were seasonal, and 4 months you were full-time. Does that sound about right?
Yeah, that is correct. Yeah.
You're saying it's now you're completely seasonal?
No, it would be basically I'm just doing gig work through apps, finding positions that I can, work at daily and getting paid that
are you
way.
not working for Six Flags anymore?
No, I do not work for Six Flags anymore. No, like I said, they made changes when they came in. They kept what they call their core staff, and they let the seasonal people go.
Okay. All right, and I think you said, but remind me when that happened, when you were let go.
That was in about November.
Okay.
Court locks mom as primary while dad faces strict limits.
Okay. So, what would you say you're making now? Well, let's put it this way. So, from December to the present, what would you say your monthly average was before tax?
Stop. Sir, where are you employed?
Go ahead. Like I said, it's through GigPro and Quick. It's like a staffing company that would be. It's like through an app.
All right, and they send you to various jobs. They send you to an employer, and they set everything else up, and you go to that employer. Correct, sir?
Yeah. So I mean, I could work in a hotel, being a line cook,
Okay.
here,
Sir,
and then I could be,
Stop, sir. I don't need the explanation. I understand how this works. I'm just trying to figure out whether or not they've placed you with someone who you work with predominantly permanently, or are you going to job to job every week, every other week, every day? What are we talking about?
Yeah, whatever shifts are available and I am chosen for, or I pick up, yes.
Do you get a pay stub, sir? I'm sorry, are you paid through the company that sends you, or are you paid by the individual companies you are sent to?
The company that sends me.
All right, then. So you do get a paycheck from them every on a weekly basis, bi-weekly basis, monthly basis?
It can be daily.
All right. I'm sorry, but do you, okay, but do you get, how do you get your pay information, pay voucher? Usually when you get a check, you get there's always a voucher on it that states what your year to date is, what your weekly is, or your day, or your monthly is. What do you
it would just,
get, sir?
it's all within the app.
All right, and you've been doing that since how long, sir?
I mean, I've been doing that on top of the other jobs. I mean, I've been with Quick for 3 years.
I'm sorry, there's another job you work at, sir?
No, and that's, I mean, that's what I'm saying. If I don't have a main position, I will do the part-time work through the app. The app is always open for whether I have a full-time job or not.
And this is the same people you've been working. Did they get you the one at Six Flags, or was that Six Flags? You worked for Six Flags.
No, I worked for Six Flags.
Okay. All right.
Yeah, I was an employee of Six Flags.
Okay, and if I remember correctly, at one time, were you ever a bartender, or is there another case I'm thinking about?
No, I mean, I do. That's what I'm saying. With the gig work, I mean, I can do bartending, serving. I mean, I can do any position that they send me to do.
All right. And sir, when's the last time you got a paycheck or a pay voucher from that company?
I mean, I actually worked a shift last night, so I mean, I got $93 last night.
All right, then, and they take out the taxes and the Medicare and the
no, everything is 1099.
All right, everybody, we need to go off the record.
I think I can save this with one question, Your Honor.
I don't think so, but go right ahead.
Thank you. So Mr. Ariano, I guess the question is that seasonal monthly $1,915.33. Is that about the ballpark of what you make before taxes going forward?
I mean, it's in between. I mean, like I said, it can fluctuate. I mean, a shift can be from 14 to, I mean, the most I've seen is $18 for a shift on the app.
Can I ask a question, Judge? Since
Right
we're all kind of throwing it in there. So this Quick company you said you worked for 3 years. Basically, Quick kind of filled the gaps between Six Flags, but now since there's not Six Flags, it's kind of your full-time gig. Is that right?
At this moment, yes.
And so when
and like I said, and it can be sporadic. So I mean, I may get a job on Monday and may not be able to get another one until Thursday.
And so the previous number that Mr. Diamond had was probably accurate for that time, but now Quick, you might actually get more from them because there's not the Six Flags job, right?
No, I mean, I can tell you, I mean, I can pull up the app and I can tell you within, I mean, like I said, it will give me all the numbers. So give me 1 second and I'll just give you.
All right, here's what we're going to do, folks. Again, I don't want to do this on the record. Okay. Again, y'all need to go back in the breakout room. Y'all need to figure this one out, guys, and get it done. I don't want to do this on my time. And that's the court. And that's the way I'm going to go with this one. Okay. Sorry. So get back into a breakout room, Mr. Diamond, get the information. Let's see if it's close. If it's not, then let me know. All right. We're off the record.
Thank you, Your Honor.
And to isolate just on the issue of support, right?
Just dealing with support, because I thought we had everything down, but obviously
I wanted to make sure.
Yeah, that's only the support. Everything else I think we got. And I really don't want to have to extend this out again. But you also need to find out whether or not, because it sounds like to me he's looking for another full-time job and he may have prospects. So figure that out also. Thank you. We're off the record for this one, and I'll let y'all get in there with a breakout room and see what math we have. And I'll see who's up next. Thank you. All right, back on the record on Bell County calls number 23 DFAM 336989. In the interest of Ariano, minor child. The court took a recess because the court found out that Mr. Ariano had left his previous job or position with Six Flags in San Antonio and was now working something else. It looks like on a job-by-job basis, or so the court reset this matter to find out what the attorneys can find out and what we may be looking at doing as far as those circumstances are concerned. So at this time, I'll ask the state for an opening to tell the court what the state's requesting what we do here based on what the information they've been able to ascertain, and to add light in the same thing, and whether or not we can make this a final hearing today or not. Thank you.
Thank you, Your Honor, and appreciate the court's forbearance. Requesting the court go ahead and make a final order. Mr. Ariano will testify that he's making approximately $2,100 a month gross, self-employment, 1099. So 3% of that would be 63 on the medical, and 0.5% would be 11 on the dental. It's 10 and some change, but it rounds up to 11, Your Honor. And then the guideline child support 266. I believe Ms. Hines will tell the court her position is that she's not thrilled with that, but she's looking to move on as well. So requesting a final order with those numbers and with the other recommendations that Ms. Cusack has made. And then if we could just get the ruling on the non-disclosure, Your Honor.
All right, let's get some testimony and get this verified. Everybody's already under oath, everybody. And so you can call it your next witness and let's take it from there. Thank you.
Thank you, Your Honor. Mr. Ariano, recall. Mr. Ariano, I think you heard what I told the court. Just in the interest of brevity, $2,100, is that about what you're making monthly before taxes or anything else gets taken off?
At this moment, yes.
Okay.
I'm sorry, can you repeat that, sir? I couldn't hear you. It's kind of mumbled.
At this moment, yes.
Okay. So I calculate 3%. You heard the numbers: 63 on the medical, 11 on the dental, 266 would be the child support. Are those numbers tolerable to you?
Yes, sir.
Okay, I appreciate that, Mr. Ariano. And I will pass to Ms. Cusack. Thank you, sir.
All right, Ms. Cusack, you're a witness.
Thank you, Judge. I think we've established all the major issues. The only thing we haven't cleaned up is getting Mr. Ariano's take on the exchange point. Mr. Ariano, you currently have been using Buda, the HEB and Buda as an exchange point, correct?
Yes.
Okay. Is that what you're asking for? Are you asking for another location, or would you agree to pick another location? What are you asking for?
I mean, honestly, I think it's been fine. We haven't had any issues. We've met there multiple times without any kind of problems. I guess, we've been, late here and there, but like you said, we've given each other, enough time to just know that we were going to be late in that hour. So no, I don't have any issue keeping it the same. Okay.
I'll also ask you, you currently are meeting at 8 o'clock. Does that work? Or do you think that Ms. Hines' suggestion of either 7 or 7:30 might make things a little bit?
I would honestly be okay with splitting the difference.
Okay. And that might help.
It was because we were, at a point we were both having a job where we didn't get off until 5. She had an hour drive home from where she was coming from. It was about the same for me. So, really, honestly, that was the reason why it's changed. Of course, with me having no job, I shouldn't have an issue getting anywhere at any time. So, no, 7 o'clock would be fine if we want to do, we'll just split the difference.
Okay, thank you. And then I'll ask you the same thing I asked Ms. Hines. Other than the issues we've already kind of clarified and isolated, can you think of any other issues that need to be clarified before we try to lock this down in a written order?
So now the only thing that I wanted to bring up on that part of exchange and stuff like that is I have already, I guess, been past the point to where I've had to get a Maya under the wrong circumstances. I would like it to be removed to where I can go to the school and pick her up. I would like to be able to pick her up and drop her off
Denied.
a regular.
Sir, denied. I'm not going there. No, we're not doing that. Okay. That's my almost agree to that. Let you come all the way in and pick her up from school. I don't like that, sir. How are you going to get there? Stop. You're saying you get there about 6, somewhere between 5 and 6. School gets out at 3:30 p.m., sir. How are you going to make that work?
Okay, but there has been multiple times
answer my question.
You don't let me answer, so I don't ever get to get anything out.
Okay, sir, here's the deal. This is the court of law. I asked you a leading question. That means you don't get to go around it. You don't get to say anything differently. How are you going to make that work picking the child up from school in Killeen, Texas at 3:30 p.m.? Tell me.
Okay. I would like to have the option because there are days when I
Okay.
do not work that I am able to, when it is my weekend, to make it to the school to pick Maya up from
Okay,
school
sir. Okay,
to
right there.
have
Okay,
her.
sir, you can stop. I'm not going to do that. Denied. Move on.
Okay.
That's my
of
decision.
course.
I'm the judge. I get to do that.
Of course.
We're not going to do an optional here. Sometimes this will work. Sometimes we need
Of
something
course.
concrete that's going to work every single time, sir, between the two of you. Because of the history here, I don't want anything to come to chance. Well, I missed it. I'm running late. I can't get there to get to school on time. I-35 is way back up. We're going to keep it the way it is, sir. So yeah, that's my decision, sir. Because I can see this one going south way fast.
I will be appealing. It's fine. I'll be
Yeah,
appealing.
that's it. This hearing's over with. I'm making my ruling. We're out of here. That's it. I am not putting up with this, sir. You say one. Okay, I'm counting to 10 here, sir. You can do anything you want. You can appeal. You can de novo. You can do whatever you want. You can go out and pay your lawyers $500 an hour to take care of what you do. But right now, I'm not happy either. I've had cases in the last year where I've seen what people who work in the service industry in San Antonio, Texas make. I know what the percentiles is. I've heard that testimony, and you're way, way below that. So, folks, I'm about 5 minutes away from making this a live hearing in Belton, Texas. I'm going off the record for now, and we're off the record for now. So, sorry, thank you. Because I'm going to count to 10 and get my composure back before everybody has to show up here in Belton and do a final hearing. Thank you.
Thank you, Your Honor.
Thank you.
Thanks, sir. What you did was technically you tried to threaten me. Don't ever do that again. Otherwise, I will hold you in contempt and you will get to do a few days in Bell County Jail, sir. Understood?
I muted him, Your Honor. I don't want him to say something he's going to
Now,
regret.
the court locks strict exchange rules and firm deadlines. Every pickup, drop-off, and message is placed under control.
Regret. I'm going to move into a breakout room if it pleases the court.
Okay, I took that again. I take those kind of things as threats, and you don't threaten judges, and I'll deal with this person. I'll deal with the ruling on this one. Is there anything else that I need to take in consideration at this point?
Well,
Again,
I think
yes,
we're
ma'am.
off the record, Your Honor.
Okay, let me get back on the record. All right, we're back on the record. Is there anything else I need to take in consideration at this point? Because again, I'm not crazy about the wage information. I'm not crazy about the circumstance. So anything else where you think I need to take up before we take into consideration before I make a ruling?
Ms. Cusack, did you need more on the pickup and drop off?
No. I think we're good on that. I think, Judge, we've covered all of the issues. I would ask to lock it down partly as what was already rendered before, and then partly based upon what was agreed. I believe that we've landed at this point after a long time of struggle, and I'm hoping to get some final orders.
All right, thank you.
Thank you, Judge.
And I'm sorry, Your Honor, I would ask that the record reflect that I muted Mr. Arellano and put him in a breakout room to prevent him from saying something he was going to regret.
All right, then. Well, again, I'm going to give him one last opportunity to make a closing statement or anything else. He wants to make a request. He's his own pro se litigant. But I'm at this point that I'm not taking any further requests above and beyond. If he can go ahead and make a request just like he did, and I can say yay or nay. So let's go ahead and get him back in here, and let's go ahead and wrap this one up.
Your Honor, it's looking like he departed from the Zoom meeting.
Okay, I'll give him a minute to see if he's going to come back in. If he's not, then I'll go ahead and make my rulings. And it's getting ready to be. Everybody's coming to Belton, because I'm going to get this. Yeah, I'm getting this one on the record. I'm going to get this one live, and I'm going to get this in my courtroom. Because if I want to send somebody to jail that day, I get to do it. Anyway, well, let's get off the record for 5 minutes, and we'll see what we're going to end up doing, folks. Thank you.
Thank you, Judge.
Thank you, Your Honor. I'll have the next hearing come and announce whenever the court is ready.
Oh, I'm ready. Was that him just coming in now?
Probably.
Okay.
Sir, on the device ending in 435, is that Mr. Arellano?
It is me. Yeah, I lost him due to my headphones.
Okay.
All right, Mr. Ariano, I'm getting ready to go ahead and give you one final opportunity to make any closing request. I'm gonna let Ms. Hines make a closing request. Again, sir, I got information in my head that most people don't have, or that has already been presented to this court as far as information concerning income and people who work what you say you do in San Antonio, Texas. If the state wants to go along with that, and the mom's willing to agree with that, and the Atlanta's are willing to agree with that, I'll go along with it. But again, sir, I'm not going to deviate and allow pickup for a child from school from somebody who's 140 miles away. I have never, ever, ever done that. Pick up and drop off at school is made for people, and under the Texas Family Code, for people who live somewhere between 1 and 50 miles. You're way past that. So again, sir, I don't think it's a reasonable request, but I'll let you make any request you want, sir. And you can, and as far as what you want to do in a closing statement, I'll let you make your closing statement and make that request, sir. But again, sir, it's left up to me to make a ruling. And as far as that option of doing that from school, even though you may have time off like that, again, sir, I'm not going to go with that. That's just something that the court feels is not appropriate at this point, and is well outside what the family code says I'm supposed to look at as far as those circumstances are concerned. And that's my prerogative. And the other thing you need to know, sir, telling the judge that I'm just going to appeal you. You have the absolute right to appeal anything I do here. But the bottom line is, when you tell the judge that on the bench, the judge is going to has the option of taking that as you trying to threaten the judge, and I can definitely deal with that also. So, but it would not be to your liking, sir. So I can have the option of fining you, or actually putting you in jail for contempt. So again, I'm going to go ahead and let you say what you need to say as far as your request is concerned, sir. But this is still a court of law, and you're held to the same standard of making any type of legal request as if you went to Baylor Law and graduated. So I'm going to go ahead and go. We're on the record, and I'm going to go ahead and let everybody make any other closing statement, or any other closing argument they want, including Ms. Hines, Mr. Diamond, and Ms. Kuzak. So thank you. So at this time, sir, is there anything else you're asking in closing?
And about what?
All right, again, sir, this is your opportunity to tell the court in a closing statement anything else you're requesting the court to do, based on the orders and the agreements you have with Ms. Hines and what's been told the court already.
No, I mean, I don't even know what has come up with the video that you guys had supposedly seen or saw. I never got any contact after the last court case. I just barely saw the email yesterday that I was supposed to be in court today.
All right, again, sir, that's not a closing statement, but if anything else, sir, I'm asking for your request at this time.
I just asked that the court just look at all the offenses and all the anxiety and all the issue and the problems that she has that causes her to become unstable and have outbursts. And yes, I am concerned because I've seen it happen. I've watched it happen. It just seems like it's just being overlooked. So, okay. I mean, I really honestly, I don't have anything to say, because, I mean, whatever ruling that you make when she becomes old enough to make her decision, she will be living with me.
Okay, again, sir, one more outburst like that, and you get to do 10 days in Bell County Jail. You understand? Do not threaten me. I take that as a threat.
Well, I mean, what's the outburst? What's the outburst?
Yeah. There we go.
I'm just letting you.
At this point, the court will let you know I have muted Mr. Ariano. I'm going to let everybody make a closing statement, and then I'm going to make up my mind. If we're not going to, I'm not going to make it this. I'm going to reset this for a live docket hearing at this point, because I'm not going to put up with this. So here we go. Why shouldn't this not? Okay, ma'am, I'm going to start with you, Ms. Hines. What else are you asking the court to do, or if anything?
Okay.
All right, ma'am. The state said that you're all right with the information concerning the father's income.
Yes, sir.
All right. Ms. Kuzak, anything else, ma'am?
Judge, I would just ask to finalize based upon everything that we have included in this list today. I think closure would be beneficial. but you know, obviously if the court needs to look further into something, we will make accommodations for that. But I would ask
I'm
for,
looking at going ahead and making this a final, Ms. Kuzak. This needs to go away. Ms. Hines needs closure. Dad technically needs closure. Obviously, Dad think he has other items he wants to bring up, he wants to talk about, but right now those items are not before the court. So I'll let you go ahead and make your closing based on that, ma'am.
okay. I would ask for a joint managing conservatorship with mom as primary, a Texas geographic restriction to the Central Standard Time Zone, guideline child support. The parties have agreed, and I agree that 266 is appropriate beginning May 1. Cash medical support of $63 medical and $11 dental, as Mr. Diamond has calculated. I would ask, the only thing that has not been finalized has been the exchange point. And so based upon what has just recently been brought up, I believe the question was whether it was going to be the HEB and Buda that has worked traditionally, but it is.
That's what that's what the court's going to stick with. What's
Okay.
worked in the past, and I was looking at changing the time to 7:30 p.m., split it in half an hour, and allow the parties to work with that.
And I agree that that's probably in the best interest of Amaya as well, because it'll get her off the roads 30 minutes earlier. The visiting parent must notify the other parent at least 72 hours before visitation so that both parents can make travel plans. App close for communication between the parents, and then non-disclosure, and then the decision that was rendered earlier about not having to produce the babysitter information, just the traditional requirements of like school and daycare, being able to know about that. And then alternating the fall break, mother gets evens and father gets odd for the fall break. And I believe those are all the orders, Judge.
All right, thank you.
Thank you.
Mr. Diamond.
Your Honor, I would agree with what Ms. Cusack said, and thank you, Your Honor, for making the final order.
All right, then, folks, again, I want to make this one final. I'm going to go ahead and set this up as requested. Joint MC, mom gets the right to side domicile. That right is going to be restricted to the central time zone of the state of Texas. I'm going to go ahead and grant the child support amount as requested by the father of the state and the ad litem in the state based on $2,100 a month. I'm going to go ahead for a person who has to pay his own taxes. So I'm gonna go ahead and grant that as the basis for that, the cash medical as requested and the dental as requested on that. I'm gonna go ahead and set up the standard visitation as requested. I'm going ahead and add the fall break that the child gets, and again, we'll do that on the even and odds. Mom gets even years, dad gets odd years, and as far as the all other aspects of the visitation is by the standard possession order. Is by the standard possession order. I'm going to go ahead and let's see, grant the was non-disclosure on this one?
We're asking that it be, Your Honor.
That's what I thought earlier. So non-disclosure is granted. I'm going to order the parties to maintain their communications through app close, 72 hours advance notice when there's going to be a pickup and drop off for the visitation. That way, well, it's for the pickup, and obviously the drop off is when the drop off is supposed to be. And that's going to be the order. That's going to be the order of the court. Is there something else specifically I need to rule on, Ms. Cusack?
I don't think so, Judge. Thank you.
All right. Anything else, Mr. Diamond?
No, Your Honor. Thank you.
All right, then, folks. I'll let both parties know you have the absolute right to do what's called de novo to the district court in this matter. You have the absolute right to appeal anything you want to, but that goes to another court, and you get to do that again in that court. But for right now, this is going to be the order of this court in compliance with the assignment by the District Court of Bell County for this matter. And the court's going to the court will waive court costs as far as both parties are concerned in this case. Anything else, Mr. Diamond?
No, sir, Your Honor.
All right, then. Do you need the parties back? Yes, Ms. Cusack. Sorry.
And Judge, am I
released from your duties 30 days after the court sign after this order becomes final.
Thank you, Judge.
Thank you. All right. Anything else then?
No, Your Honor. Thank
No,
you.
Your Honor.
All right, Ms. Hines. Anything else, ma'am?
No, sir.
All right, thank everybody very much, and I'll let the state prepare that order. Are the parties free to go at this time, Mr. Diamond?
Yes, please, Your Honor. Ms. Cusack has some language that she likes for the fall break, and so I was gonna use that, but it'd probably be a little while before I can get going on the order.
All right, well, I'll have you go ahead and we'll go ahead and let the parties go and let you draw up the order and circulate it by DocuSign as you normally do. Thank you very much, and we're off the record, folks.
Watch
All
the
right.
judge shut him down. Denied on the spot as planned to pick up from school collapses.
All right, is Mr. Arellano present also?
I don't believe so, Your Honor.
Okay.
I have not seen him, Judge.
I just want to make sure. Anyway, the court's going to go ahead and go on the record. And this is Bell County Calls number 23 DFAM 3368. I'm sorry. This is Bell County Calls number 23 DFAM 336989. And this is in the interest of Arellano, minor child. Non-custodial party is Randy I. Arellano. Custodial party is Benicia M. Hines. And this matters before the court on a motion regarding entry of temporary judgment order or alternate motion for hearing. Is this for a final hearing of Mr. Diamond this time, or are we still looking at temporary orders, sir?
It should be a final. If the motion says something else, then it's wrong, Your Honor.
Okay, so it says okay, but it says temporary judgment, but then again, doesn't tell me y'all trying to make a temporary judgment, trying to make a temporary judgment. We had already a final. All right, the court will just let you do that, let you go with that interpretation, sir. And the court will note for the record. All notices were of this matter were tendered to all parties, to both parties, and to the ad litem who is present. Ms. Hines is present. Mr. Arellano is not, and we'll go ahead and proceed in default of Mr. Arellano at this time. And I'll ask the state for an opening to tell the court what agreements you may have with the ad litem and Ms. Hines, and whether or not and what issues y'all may have at this time between either the ad litem or the custodial party. Thank you.
Thank you, Your Honor. So requesting the court to grant the proposed order or enter the proposed order. I don't know if Ms. Hines has any objections. I don't believe Ms. Cusack does.
That is
All right.
correct.
All right, well, Ms. Hines, do you have any objection to the court entering the order as presented to the court at this time, ma'am?
No.
All right, Ms. Cusack, on the record, you do not either, correct?
That is correct, Judge.
All right, court will grant the motion at this time and sign the order and make it a final, and that will take care of these circumstances. Sorry to make everybody hang around all day on this one. Well, not quite all day yet. But anyway, is there anything else on this one, Mr. Diamond? Again, this is going to come in via DocuSign or e-file, sir.
Mr. Diamond, I can probably sign it just like I did that other one and send that to you, and wait, I'm sorry. I'm not sure if Ms. Hines signed it. Let me double check.
So she signed the original one, but then it timed out and I sent another one out, and I don't know that she got a chance to sign that.
Okay.
All right. All right, Ms. Hines, you go ahead and sign that new one. DocuSign's like that. If you don't do it in a certain amount of time, they go, okay, something's wrong here. We're going bye. So anyways, get that and sign off on it, ma'am. And like I say, I'll sign it immediately. Thank you. All right, anything else for folks?
But just that was my mistake that it timed out. I mean, Ms. Hines did what was asked of her.
Right, no problem. Yeah, believe me, sometimes the computer does things faster than we're ready to deal with, so not a problem, sir.
And I'll just go ahead and take my part in that too. It could have timed out because of me. So, but I just know that there was one change that we had to make on the visitation, and then Mr. Diamond made that one quickly, and then I just don't think I signed it after that.
All right, then. Well, anyway, I'm noted on the docket that I've granted the entry of the order, and like I said, I'll double check it on and sign off on it as soon as I get it. Thank you.
Thank you, Your Honor.
Ms. Hines, free to go?
Is there any way, Your Honor, people could stick around, guys? Because I can have this thing out in probably less than 10 minutes, and that way it's in the bank.
Okay. All right, then.
That's not too much.
Maybe hang around another 10 minutes, but it'll just take care of you for good. So we'll get you out of here, ma'am, before 2:45, and you should be getting there to sign off on it. Okay. Thank you.
Okay. Thank you.
All right. Thank you both very much, and we're off the record.
Thank you.
Thank you, Your Honor.
Case closed. The gavel drops, and the fight finally ends here. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.